Okay, so I'm going to skip ahead. I'm going to ask you a favor. Like, do you mind drawing out how he had his, because if I'm watching this right now, I'm saying like, well, Jeff, I think I'm protected.
Right.
Do you mind, and so this gentleman thought he was protected. Do you mind showing us like what the typical protection is that most people have?
Yeah.
And you could share his example directly, and then how you would just restructure that to have him fully protected.
Yeah, so here's what I'm gonna do. I'm gonna walk you through what I call a good, better, and best approach, okay? Now, and this may apply to a number of folks who are watching this. To start off with, you say, how do I get a good approach? 70+% of short-term rental owners have the property in their personal name. They close in their personal name. How do they get this asset out of their personal name into an LLC, okay? Good. What is the good approach? Now, why do I call it good? Well, because at a very basic level, you have got to get these assets out of your personal name into an LLC. The whole concept of an LLC is a limited liability company that I said earlier, you separate your ownership of the asset from your control. You legally do not own it anymore. Okay, so essentially now you do not own it, but you control everything. That's the goal of asset protection. So how do we do this? Now let's say you've got the example I showed earlier, the guy in Tennessee, right? He's got his Tennessee property. Well, right now it's in his personal name. He purchased this, and I could go into more depth in this about if you buy in a conventional loan, you cannot close in an LLC. It's not allowed. So the only way you can do this is you close in an LLC, or you close in your personal name. Now you have to convert this into an LLC. Now, in order to do that, how does this work? You have to do a deed transfer, okay? And I know my handwriting's not the greatest, but you have to do a deed transfer. In order to do this though, if you move the property from your personal name into an LLC, this must happen. You mentioned this earlier, Ed. What are some of the misconceptions? I have many people who come to me and say, hey Jeff, I already set up an LLC, but the property is still in my personal name, but I'm doing all of my banking out of that LLC. I'm good, right? Absolutely not. Yeah, unless you move the property into this LLC, you have no asset protection. You're just using the LLC as a management company, a property management company, and it's providing you no asset protection. So you must transfer it over. The problem is, when you do this, you're going to run into three main issues. Number one, what do you not know? You don't know what you don't know when you do this, and I run into this all the time with people. Number one is a concept known as real estate transfer taxes. So hopefully you can read that. So essentially what this means is about 2/3 of the state in the country have a tax. If you move an asset from your personal name into an LLC, the government's going to come in and say, thank you very much.
Wow.
That can be anywhere between 0.2% up to 3% of the value of the entire asset. Now, imagine this poor guy here.
Yeah, so if you own $1 million property, that is anywhere between $2,000 to $30,000 in just pure taxes to fix this issue.
That's right, if you don't handle this right. So I have a lot of people that'll come in and tell me, hey Jeff, I'm gonna just do this on my own. I heard somebody on the internet tell me that I could just do what's called a quitclaim deed. And I put this in here because I write it in red because that's a big no. Because here's the problem, if you quitclaim deed it, when I was in law school, you could quitclaim anything. Basically, they teach you that you could quitclaim the moon if you wanted to. It doesn't mean you have an ownership interest in it. But all you do is write up a form. But guess who pays attention when you quitclaim deed something? The government. The government. So in this situation, this is just one of your first issues. The second issue, and this is less of a concern, but there's something known as the due on sale clause.
Okay.
Now, why does this matter? This is critical if you currently have a low interest rate. All of you that bought properties back in 2020, 2021, and you were getting them at 2.5%, 3% interest. If they're still in your personal name and you want to move them over into an LLC, unless it's an FHA, Fannie or Freddie product, if you try to move that over, here's what's going to happen. The mortgage company, and this is happening right now, Bigger Pockets did a big episode on this year, And what they did is they said there are due on sale clause investigations where when you move this property from your personal name in a conventional mortgage over into an LLC, you signed a contract with your mortgage company, not your LLC. So the moment you move this asset over, you breached your contract. So here's what happened. Rocket Mortgage, actually, a guy called me just about 8 weeks ago. He was at a 2.89% interest rate. He quit claim deeded the property over into an LLC. Rocket Mortgage called him, accelerated him to a 6.9. Now, he had two choices. He was either going to have to pay the entire amount of the note all up front because they called the note due, or he was now going to have to go from 2.89 to 6.9%. Now, Ed, how do you think that affected his cash flow?
Oh, tremendously.
I mean, it devastated him. So he didn't even know this could happen. Finally, point number 3. And forgive me if I'm getting in the weeds too much here. Point number 3 is, what if you want to do a refi? Okay? Now, this is really important. If you're in a state with a real estate transfer tax and you move the property into this LLC, and let's say you're fine with choking up and paying the first time, what about people right now buying at 7 to what may soon be almost 9%? What if you're in the 7 to 9% range? You think they're going to want to refi that later? Absolutely.
Absolutely.
They're not going to want to sit at that amount. What goes up must come down. The rates are going to come down later. When they do come down, what happens when you want to now refi a conventional mortgage in an LLC? The mortgage company won't let you. So now they're going to tell you, pull it out. Well, Ed, what do you think happens when they pull it out? They got this again. So they're going to get hit not once, they're going to get hit twice. They have to pull it out to refi, right? And then they have to put it back in.
Which costs $2,000 to $30,000.
That's right.
Depending on what the.
That's right. And then what happens when they finish the refi? They still they got to do it again.
Wow.
Now that's like, unexpected closing costs you didn't expect were going to hit you on a refi. The solution to this, and I don't want to just talk about problems, the solution to this is a land trust. Okay? So when we talk about a land trust, essentially what happens, I'm going to show this as another illustration here. When you talk about a land trust, here's what happens. Now what we do is you've got the same Tennessee. You say now we've got a new Tennessee LLC, right?
Yeah.
And now what do? We use a land trust, and I'm going to explain what this is. A land trust is a simple grantor trust you move land into. You move property into. Now, there's two components to a land trust. There is a trustee, and there's a beneficiary. Now, let me explain the brilliant thing about this. I kind of call the land trust like your Swiss Army knife, your utility knife in real estate. Here's the great thing about it. You would set up, you as the owner would be the beneficiary. You move the property into the land trust. It actually holds that, okay? Now, when I want to avoid these, remember we put all these in red down here? Yeah. I want to avoid all this stuff. I don't want to have to deal with any of these issues. The way to do that is to assign your beneficial interest in this land trust up to your LLC. It's called an assignment of beneficial interest. It's a legal documentation that you can put together. Now, here's the brilliant thing. If you work with us or who are a third party or another attorney, if you have a trustee would be your lawyer. They file it in public record and it lists us as your attorney being the trustee at first.
Which creates the privacy.
That's right.
And,
It creates privacy. We resign as soon as we file it. You become the successor trustee, but in public record, it still shows us.
Wow.
What if you get an unscrupulous lawyer trying to come around and find out who's involved in this? We get to say attorney-client privilege. It's not us.
Wow.
Okay, so totally off the books. No one knows you've done it, but you can now assign your beneficial interest into this LLC. What is a beneficial interest? It's anything worth suing. It's anything that has value. You now assign it into the LLC, but the property never left the land trust. So because it never left the land trust, what does that mean? No real estate transfer taxes. What does that mean? No due on sale clause, because under the land trust, there's a law known as the Garn State Germain Act from 1982. It says if you use a land trust to convey ownership into an LLC, there is no due on sale clause. Okay, now I know I'm giving you a lot here, Ed. The last part, though, that's important, we talked about the refi. Well, all you got to do is reassign your beneficial interest back to the land trust. We convert the land trust to a living trust. Complete the refi. It's called restating the trust. Complete the refi, move it back into the living trust, back into the LLC. No real estate transfer taxes, no refi problems.
And just so everyone understands, this is what you do for people. So Jeff's teaching this to you so that you understand what's possible for you to do.
That's right.
This is not like for you to like be making notes to go do it yourself, because it's just, first of all, you're not qualified to do it, and second of all, obviously this gets in the weeds a little bit and is a little advanced.
Okay, I know I got a little granular with everybody, but let me just give you a quick recap on the good. Good is you have to get this out of your personal into an LLC.
Yeah.
And sometimes you have to use a land trust to help bridge the gap.
Yeah.
Okay? Now, when we talked about this, the gentleman, the story that I told you about earlier, he couldn't even seem to figure this part out because he was overwhelmed with how to navigate this because he didn't want to have to pay those taxes. He felt like insurance was going to be enough.
And so he kept just like banging away, adding one more rental property, one more rental property,
That's
one more
right.
rental property. And the foundation just he was on sandy ground.
That's right. And now he did have one of his other properties in an LLC out of another state. Remember I talked about Florida. The problem is the property that he had in Florida, the real question is an LLC enough?
Yeah.
And here's the mistake that he made. This LLC that he had was single member. A single member LLC is, and here's how this happens, Ed. A lot of CPAs will recommend that you put your property in an LLC, but they'll tell you you should do it in a single member LLC because it's better for your taxes from you can be labeled a disregarded entity, which means you don't have to file a tax return, okay? The problem is there's an old saying in asset protection, if the IRS disregards you, then there's a good chance the court's going to disregard your protection. So a single member LLC can be very deficient if this is all you're relying upon in order to protect your assets. The other problem I see people do, other common misconception that comes up all the time, is people want to put multiple properties into one LLC.
Right. So the good is actually really designed for one property.
Yeah, maybe one property, if you're just starting out, is to get it out of your personal name into an LLC. Well, once you start doing what you said, Ed, which is now you're adding properties, right?
Yeah.
So the number one misconception is somebody will go, oh, I'm going under contract. I'll just put it in the same LLC. Well, the problem is you're putting all your eggs in one basket.
Yeah.
What do you think's going to happen if in the past, if I was the one bringing the lawsuit and something bad happens at one of your properties? What do you think is going to happen? I'm going to be licking my chops because I'm going to say, wait a minute, now I've got two properties in one LLC.
That's right.
This is fantastic. I'm going to be able to force a sale on both. Yeah. Okay? And that's the negative here. We go from good to, frankly, we need to start talking about better. If you're going to become a real investor.
Well, can I ask you to explain, like from a personal injury attorney's perspective, why are they licking their chops at this when they see multiple properties under one LLC?
Yeah, well, the reason why is because if you've got now, let's say, two properties here in this LLC, one bad thing happens, slip and fall. I'm going to bring a lawsuit against this LLC, and I'm now going to be able to, if I win, I can get what's called a charging order. A charging order is basically a right that I can have to make you sell everything in this LLC.
Yeah, so if you have four properties, all four properties are frozen upon this, and then the attorney and the plaintiff, I guess, has the ability of getting all of it.
That's right. So you're exactly right. That's a very good point on your part, which is as soon as the lawsuit happens, everything in this LLC freezes. You can't move anything out.
And I think that's one of the scariest parts, is that if I have four profitable properties and I have one small incident, and it could be a small incident from just somebody who's whatever, and all of a sudden everything's frozen, well, I might not be able to move cash flow out to pay for any of this stuff, all of a sudden.
Yeah, we see, and I'll show you here in a second how that's actually even a concern on the better. because we talk about good, better, and best. But even putting multiple properties into one LLC, I see this as a very common thing. I mean, I've worked with people that are, I thought, fairly advanced investors, and they are, but they thought they were protected by putting multiple properties into a single LLC. So I tell people, here's the rule. One property, one LLC. One business, one LLC. Isolate the risk, segregate the property. Don't put yourself in a position where all your eggs are in one basket. It's unnecessary risk. So we don't want to do that.
Let's do better now.
Now, so let's talk about better. How do we move? Yeah, let's do that. Let's talk about better. How do we get to better? Well, this is where now you're going from one, instead of having one property, you're doing two, right? Let's say we're moving up. We're getting at least 2 to 4 properties, right? Why not just stick with an LLC? Well, there's 2 negatives about only using an LLC by itself. There's 2 things you do not have. You do not have privacy in most states, and you do not have charging order protection. I kind of gave you a little bit of hint on the charging order protection a little earlier, but why does privacy matter? Because I told you earlier, if I can go and find who you are as the listed member from the Secretary of State, I'm going to sue you personally, and I might be able to pierce the veil. And if I can get a charging order against you, I can make you sell your property to pay the attorney.
That's crazy.
Now, how do we avoid that? Now we do what we call a holding company strategy. This same situation here, we could have that Tennessee LLC, okay, now owned by a Wyoming holding company LLC. Now, why does this matter? Here's the way it works. You can keep the single member LLC, but now you don't own it. It's important. If you have it owned by the right state's holding company LLC, let me give you the anatomy of a lawsuit just so we break it down, because we're back on that again. If I'm going to bring the lawsuit and I'm a Tennessee attorney, I'm going to go to the Tennessee Secretary of State, and what am I going to find? I'm going to find now, instead of it being owned by you, it's owned by a Wyoming LLC. So I now have to go to a Wyoming Secretary of State, and they're going to say, stop right there. Here in our state, we have special beneficial laws where we cannot give you the names of the members. So, and I've done this as an attorney, and I'm like, okay, I can't bring a lawsuit against the members because I don't know who they are.
Yeah.
But secondly, any good lawyer is going to now know, what do you gain from this? 2 big benefits. 1 is privacy. Number 2 is the charging order protection. Now let's talk about what that means, and this is huge. Now, as an attorney, I know that if I bring a lawsuit starting here and I extend it into Wyoming, even if I win right here, Ed, I still lose because I can't make you sell. Charging order protection means you can keep renting it out. You can keep paying all your expenses, your mortgage. You can even pay yourself an operator's fee. Yeah. The only thing you can't do is pay yourself a distribution. So think about what this does now. How do personal injury lawyers get paid? And some of you may not know this. They get paid on what's called, we get paid a percentage of the recovery, just to keep it simple. We get paid a percentage of the recovery. Well, what if I can't recover?
Yeah.
What if I can't make you sell? What does that mean? That means now I don't get paid if I'm the personal injury lawyer, the client doesn't get paid, and the attorney has to pay all the expenses under a contingency fee arrangement out of their own pocket on the front end. So you become very unattractive when you set it up this way.
Yeah.
And especially when we use the example you gave, Ed, let's say now we're talking about a Florida LLC as well, right? You can have multiple properties that are owned under the same holding company, all of them single member, so you do not have to file tax returns down here, but every one of these properties gains the benefit of privacy and charging order protection.
And so, just so we're all clear on this, so then that means that on the personal injury attorney, he's going to go back to the client and say, you guys will just go after their insurance because that's the default.
That's right. Good asset protection, and this is significantly better than the good. And I know we're mixing examples
That's
here.
okay. No, we're good. I think this is really good.
This is significantly better because here you're very unattractive to me as a personal injury lawyer. Good asset protection pushes attorneys down to good insurance every time.
Yeah, that's right. That's a writer downer. Good asset protection pushes attorneys down to good insurance every time.
That's right.
That's amazing.
Yeah, and so that's why we talk about layers.
That's why you get insurance.
That's right. You've got to have
right insurance. Yeah, totally.
100% correct. And at the end of this, one of the things I want to give everybody at the end, Ed, is I want to remind them of all the layers of everything they need to know. But this right here is a lot better. We talk about here, you're adding something you don't have up here. Okay? Now, what's the limitation?
Okay.
The only limitation to this is, let's say you're really investing, you're scaling your portfolio.
Yeah.
Let's say you buy in Gulf Shores, right? Let's say you're going to buy in Colorado. Maybe you buy a Breckenridge property or something and you're going to rent it out. So now you've got all these LLCs. You have this, you have privacy and charging order protection, but what happens if one of the properties gets sued in Alabama? Let's use this one as an example. What if this one gets sued? Well, what's the effect? If I bring a lawsuit against this Alabama LLC and now it's in litigation, here's the problem. Everything in this Wyoming LLC holding company locks down.
Got it.
So think about it. If I've got, let's say we're talking about more than 4 or 5 properties, now I can't move any of these properties out of this holding company during the lawsuit, and if I have any money that was going to be used from the entire portfolio to help improve properties on that portfolio, I can't use it. There's a concept known as fraudulent transfer analysis. Fraudulent transfer analysis means that under this structure, the way that an LLC is just designed by law, you can't move anything out of it once you're sued.
Got it.
So imagine people with larger portfolios. They don't want to be held hostage, feeling like there's no way to be able to manage their portfolio just because one of them gets sued.
Can I ask a question? So you're using different states there, but hypothetically, if I have, say, 6 in Tennessee, same exact scenario, correct?
Correct.
I just want to make sure if you're watching, you're like, well, I have all mine in Tennessee. Why does it matter? Why the Alabama doesn't apply to me? It does.
Yeah, I'm glad you mentioned that. That's correct. I use this as an example of a diverse state portfolio, but it would be the same.
State portfolios would have the same issues.
That's correct. Right. Same concern, because your holding company, the way the law or the courts have interpreted this, they are looking to see if you're moving anything under this structure that would be a fraudulent transfer. And the point of a fraudulent transfer, which is why you would move it around, is to avoid it being taken in a lawsuit, right? And so the one thing you do not have here is you do not have what we call, and I know this is more of a lawyer term here, you do not have post-lawsuit flexibility. You don't have that, which means you're not allowed to move these assets out of here if you're scaling, if you're going to add more.
Makes sense. Okay, so how do we fix that?
All right, so now let's go to the best. Now we talk about a best structure, and this is perhaps the most comprehensive that you can, that allows you to take care of all of these issues. So under the same example, let's say we've got now a, I'm just gonna.
And like while you're writing that, like one of the things that Jeff and I talked a lot about yesterday was that you have different types of short-term rental investors. You have people that they have one property and they're totally happy with that. There's no desire to move outside that. Well then, the good and the better might be perfect for you. But if you're growing your portfolio and you're trying to build wealth or you already have built wealth and you're trying to protect it, this is where really spending the extra either money and time and having an advanced best asset protection strategy is not only the responsible thing to do for you and your family and your generations, but it's really just to make enjoy your growth of that snowball, And so this is unbelievable to me.
So, and that's a very good point, Ed. Look, I'm a huge believer in building a legacy, but I'm also a pretty big believer in making sure that you protect that legacy. And I use this as an example because let's say we're talking about a growing portfolio. LLC, maybe I say Tennessee, Alabama, Texas, Oklahoma.
But this is true with even, sorry to interrupt you, this is true for entrepreneurs. So I'm growing I have 2 businesses. A lot of guys who own 2 businesses, or whether they're even doctors with multiple practices, they own multiple locations. Right. These things, this sounds complex, but this adds up really quickly and easily. The complexity adds up really quickly without you not even knowing it.
Yeah, that's a really good point, which is I've got clients that I work with that have short-term rentals. They have apartment complexes. They have long-term rentals, doctors with multiple locations that they put them in separate LLCs for exactly this reason that we're discussing here. All of this transfers over, and the primary strategy here is, as I get bigger, I'm a bigger target. As I have more wealth, I'll become a bigger target. And what are our main goals? This structure here I'm about to go over with you, you still want to keep your privacy. You still want to keep your charging order protection, but now you want that post-lawsuit flexibility. You want to make sure that if something bad happens, you're going to be able to find a way to not have everything else at risk and still have the ability to manage your portfolio.
You need to make sure, so post-lawsuit flexibility, it's an advanced lawsuit, or it's a lawyer term. Yeah. So what that just means is I want to still be able to run my businesses even if one of my properties gets sued.
That's right.
And to enjoy the cash flow and still grow and whatever. Okay,
which is
what we're going to talk about here.
That's exactly right. Much better way to say it. That's exactly what it is. So here's what we do. Same structure in theory. Every property should still be a single member LLC. Owned now, instead of by you or a Wyoming LLC, it's owned by an Arizona limited partnership. The best way I know how to describe these is many people have heard of real estate syndications, where real estate syndications maybe like Grant Cardone has a fund, right? He'll tell you, come and invest in our 500 unit apartment complex. Well, here's how that works. If Grant is the one running the fund, if Grant's running the fund, he is the general partner. And because he's the general partner, he has the red line of liability.
Oh, wow.
So what that means is the general partner who's in control of everything, that's Grant. If you and I, Ed, if we invest in his fund, I have no idea what Grant Cardone's doing. I hope I get paid. I hope it goes well, right? So, and I would trust that he's going to do that, but since I'm not involved in the day-to-day, what am I? I'm a limited partner, okay? Here's the great thing that you can do under this structure. In this structure, we set it up where we set up a limited partner, revocable trust. You can also use an irrevocable trust right there that owns 99.5% of the entire portfolio. Then we set up a Wyoming LLC that owns 0.5% of the portfolio as the general partner. Now, let me explain how this works, the beauty of this. Number one, you don't have to file any tax filings down here, so it's tax efficient. Number two, if I bring a lawsuit, here's the way it works. Let's say I start in Alabama, okay? I go to the Alabama Secretary of State, bringing a lawsuit. What do? I find out it's owned not by you, but by an Arizona limited partnership. When I get to Arizona, I go to the Arizona Secretary of State. Under the law, this, and if I had a color to show this was invisible, I would. You cannot see it. You cannot see the limited partner trust. Private, totally private. Normally, I can see the general partner, but if I use a Wyoming LLC, Ed, we talked about this earlier, yeah. If I use a Wyoming LLC, can't see it, can't see you either. So you're completely check the box. What are our check the box? Privacy?
Privacy, yeah. Charging order protected.
Charging order protection?
And now you're for post-lawsuit flexibility.
The reason why we know charging order protection is also covered is because Arizona statute's written like Wyoming, very similar. Now, where's the post-lawsuit flexibility? If I bring the lawsuit against this Alabama LLC, and that's where it starts, right? Just to come back to it.
Yeah.
Bring the lawsuit here. What happens to all the rest of the properties?
They would normally be frozen.
Everything normally.
In the better.
That's exactly right. Normally, everything would be frozen. You can't do anything about it. You just have to resolve the lawsuit. Now, under this structure, first of all, let me share with you the preventative nature. I've brought a lawsuit against this, and what happens is if I bring a lawsuit here and I go to Arizona, what do you think the odds are, Ed, of an Alabama injury lawyer being licensed to practice law in Arizona? Almost zero. So can I tell you what's going to happen? They now have to go get co-counsel in Arizona. Which costs more. Yeah. Secondly, I can't even see this limited partner trust. The only thing I can see is the general partner Wyoming LLC, and I don't see very many assets.
That's right.
There's almost nothing there. So what does that do? That leads me, can I tell you, because I've been there, this attorney now, this personal injury lawyer, here's what he's going to do. He's going to look up here and go, he hasn't even brought it into Arizona yet. He's going to look up and go, oh God, I got to go bring in another lawyer, and I don't see very many assets. They're going to have a sit-down conversation. Ethically, they have to do this with the slip and fall person in Alabama and say, guys, look, we can bring a lawsuit against this structure if you really want to, but I'm going to warn you, not only do we have to add another lawyer up here, which is going to cost more, but I'm not seeing much here. There's a very good chance you're going to end up with a lower recovery if we go through this than if you just take that insurance that's sitting out there right now. Now, that by itself is preventative in nature because you could be spending 6 figures trying to sue through this.
Now, okay, say that again. So you're saying that a slip and fall person might have to spend 6 figures to get through all that.
And here's why. One of the things that comes out of a settlement off the top is the attorney's fees. Off the top.
Yep.
So what if you're getting a recovery, and it might look like you're getting a sizable recovery, but the attorney is making an extra 6 figures out of the recovery.
Yeah.
So now whatever was coming to you is not coming to you anymore. And I know we're talking about this from a different perspective now. We're talking about it from the person who would try to bring a lawsuit against you. So it creates an actual ethical duty on the attorney to go back to that client and say, hey, this is a huge risk right here. I mean, I'm going to make money, but I can't guarantee you will make more money than me. I could end up making more money than you.
This is great. I'm just taking notes. So one question on this. Yesterday we talked about, like, does the Alabama LLC move over underneath the general partnership, or this is covered exactly? This is exactly the way it is.
So yeah, you're moving me to the next thing. So here's what happens, and which is good. Here's what happens now, and I almost forgot this, Ed. Here's the great thing about this too. This piece not only is I'm going to show you the protection, what happens here, but remember, you also have a trust. This takes care. No probate court. No will contest. The trust can take care of all of your estate planning. So it kills two birds with one stone. Wow. This trust can not only act as your limited partner, but it also allows you to take care of all of your estate planning simultaneously within the same structure. Yeah. So that's a huge component for a lot of my clients because they want to know that their estate planning is taken care of and their asset protection. So this comes back to what you asked. I just wanted to make sure to include that. What happens now if they decide bad case? Let's say someone dies or paralyzed or something like that. And it doesn't matter if there's a risk or not. They're going to extend this lawsuit into Arizona. Arizona statute says this: in the event of a crisis event, and a lawsuit is a crisis event, the law says that the limited partner trust may sever the relationship with the general partner Wyoming LLC after the lawsuit, as long as two things are present. Number one, you need to have the limited partnership agreement must provide that it's allowed to happen in the. You have to write it.
It's got to be in the agreement.
That's right.
So it's got to be. So this is really important because I just learned this. So that's what's important about doing it correctly. That's someone who knows what they're doing. And with all due respect to like we all hire friends as our attorneys, and they're like, oh, I can just write this up to you. But what you're saying is, if they do this part wrong, you're still exposed.
Absolutely. If this limited partnership agreement is not drafted properly, every bit of this is vulnerable. Wow. So number one, you've got to draft this properly, and then number two, you got to do it before you get sued. Got it. If you try to throw this together, remember the example I shared? Yeah, the guy I talked about earlier, I couldn't put this together for him because he'd already been sued in Tennessee. So I tell people this, it's a peacetime effort, not a wartime affair. You can't throw this together in the middle of bombs going off and you're already in a lawsuit. If this happens, here's what takes place. Now the limited partner trust can do a buyout agreement for the 0.5%. There can be a severance between these two. The limited partner here can take all the remaining assets and exit. Oh, wow. Now what are you left with? Now the only thing you're left with, just for illustration purposes, the only thing you're left with now is the original Alabama LLC that was being sued in this 0.5% that's remaining. Yeah, wow. Now I've got a client with 89 properties. He loves this. Yeah. Why? Because he knows that if one of them gets sued, and it's a really bad liability event, he can take all the rest of his assets, leave with the limited partner trust, set up a whole new structure, and the only thing he has left to contend with is the Alabama LLC and 0.5%.
That's amazing.
And so notice how different it is though. The reality of it is you got to be good before you can get to better. Yep. And if you've got more than a few properties, best gives you quite a bit more. Yeah. The problem with it is most people have never even heard about the best, or they don't understand how it all ties together.